Can I just check that you can hear us? If you could perhaps put your camera back on. Thank you very much. Now, my next topic is just to turn briefly to the litigation in Australia, which you referred to earlier in your evidence. I'm, for the most part, going to take this, just draw out what you say about it from your statement, with one exception on something that I want to raise with you. So just to go through the background, if we start, please, with paragraph 26 of your statement. It's page 11, please, Sarah. You explain there that on the 16th of April 2024, the Australian E-Safety Commissioner issued a takedown notice to X Corp to remove in Australia video content depicting the attack by reference to, I think, 65 specified posts on X at the time. Is that right?
Correct.
Thank you. And Ms. Cananishu, I think you set out what happened afterwards, that X promptly made those posts inaccessible to users in Australia, but communicated its intention to file a legal challenge.
That's correct.
Thank you. I think the Commissioner then applied to the Federal Court of Australia seeking the permanent removal and/or restriction of the content for all users of the X service on a global basis. Paragraph 27 of your statement.
Correct.
An interim injunction was issued. You deal with that in paragraph 27. But then, turning to paragraph 28, on the 13th of May, the Federal Court of Australia rejected the application for an extension of the injunction, and the injunction was entirely dissolved by the court. Yes?
Yes.
Thank you. The court held that the Commissioner would not succeed in blocking access to the 65 URLs to all users of X globally. You deal with that in paragraph 28 as well. Effectively, I think, taking it very shortly, there wouldn't be jurisdiction of the Australian court to seek a global restriction in that way.
Correct.
Thank you. So paragraph 29 of your statement, again, I'm just dealing really with the headlines because they're not in dispute. The court held that it could not determine what users across the world could see. And it was noted also, as you deal with in paragraph 29, that it could be viewed other places online. The court, I think, recognised paragraphs 30 to 31, a matter that I've already raised with you, that Bishop Emmanuel himself was not opposed to the video remaining on social media. Is that correct?
That's correct.
And then the Commissioner, paragraph 34 of your statement, again, taking it shortly, page 13, the Commissioner discontinued the litigation and we note paid X's legal costs as well.
Correct.
And the Commissioner agreed to set aside the removal notice as well. And I think as a result of all of that, come July 2024, the footage that we've been discussing remained visible on X to those who were logged into an account who were either adults or children who lied about their age.
Correct.
Thank you. One aspect that's not dealt with in your statement is just this. If we could look at the actual judgment of the Federal Court, please. It's XRUC 4023. And could we go to page 19, please? We do see there, don't we, at paragraph 46, that the judge did say that I have no doubt that removing the 65 URLs from its platform altogether would be a reasonable step for X Corp to take, in the sense that a decision by X to take that step could readily be justified. There is uncontroversial evidence that this is what other social media platforms have done, and that X Corp would not be in breach of any United States law if it took this step. So just pausing there, that there was an indication, not as a matter of law, but as an observation, that as an organisation or corporation, you would be justified in removing it, and that there was uncontroversial evidence that that's what most other social platforms had done. Yes?
Yes.
The judge went on to say that's not the test, one infers the legal test, and dealt with why the Australian court didn't have jurisdiction to impose that upon X, and hence you were successful in that litigation. Would you agree?
Yes.
Did X Corp reflect on matters, the judge having indicated that it would be reasonable for X Corp to remove the material like most other social platforms had done?
I'm sure there was I wasn't here during that time, but I'm sure there was a discussion after the judgment was received.
And we should infer that X decided to maintain the position that even as a matter of discretion, and even though, as I think you've accepted, you could make a case that it was a breach of the policy, X decided to stick with its current policy.
Correct.
Thank you. The court was, however, flagging, albeit in gentle language, that by this time X was something of an outlier compared to other social media platforms.
Yeah, correct.
Thank you. That can come down from the screen. Before we come back to what happened in the months following that, I just want to deal with AR's use of X and the disclosure that's been given. Could we just have on the screen, please, XIUC 30128? And you will see, I'm sure you're familiar with this, this is the Section 21 notice that was served by the inquiry on XIUC. And do you see in the middle of the page that what was being asked for was please provide any information, including user account details, username, any linked identifiers, communications and record of activity available to X in relation to the email addresses, telephone numbers or handles, and then a number were listed. So that's what you were being asked to provide under order by this inquiry. Do you follow?
Yes.
Do you note the generality of the words, any information including user account details?
I'm sorry,
Yes.
Can you repeat the question?
Do you see the broad generality that the request was for any information, including user account details, and then a number of other things, available to X in relation to the accounts? It was a deliberately broad request.
Yeah, I'm sorry, I can't respond to how it was the discussion by which the attorneys defined what any information means. I am not an attorney, and so I can't speak to that.
In response to that, that led to the identification originally. It's not dealt with in your statements, but I'm just going to summarise what the inquiry has been provided by way of disclosure without bringing it all up. So I think you'll be aware that that led initially to the identification of 4 X accounts associated with AR. So for your note, the last 4 digits are 0288, 0065, 1584, and 5419. And what was provided by X in relation to that was the non-content data. So there's what was provided in answer was slightly looks like hieroglyphics on the page, but one can work out that what's being provided is who AR was following and who may have been following him, but not, I think, the actual content of any messages that he provided. Do you agree?
I believe so.
Right. The information with which we've been provided is that one of those accounts was deactivated in 2021, so that's 0288. Are you aware of that?
I am not, I'm sorry.
And that of the other accounts, 2 were deactivated in 2023, 5419 and 0065. One of those accounts, so it's the one 5419, was in use at times in 2023 before being deactivated, and we have said the disclosure in relation to that. Would you, perhaps just to complete, that the final account, 1584, was deactivated on the day of the account itself, on the 29th
I'm
of
sorry,
July?
I'm not privy to the details on the accounts. That's something that we'll have to follow up with you on, and our legal team will have to respond.
Right, you've not looked at the disclosure that ex-IUC has provided?
I mean, if I did read through it, I didn't memorize the details enough to confirm or deny what you're walking through.
All right. Can I just add this for completeness? And if anything that I say when you look at it subsequently with your lawyers is wrong, you should, of course, correct it.
Of course.
But
Yep.
in correspondence received last night, ex-IUC informed us that a mistake had been made and that, in fact, due to a data entry error, 3 more accounts from AR had been found that were associated with the email a.mega7. And so those were 0832, 5689, and 0228. But I think one of those was a duplicate of one of the accounts that had already been established. And we were told that one of those were deactivated in January 24 and the other in August 21. But again, I don't think you're across the detail of that.
I'm sorry, I'm not across those details. But as you said, if there's anything that is in conflict with that, I'm sure we'll notify you.
Thank you. We can see from the disclosure in relation to the account ending 5419 that AR did send messages. We just can't see the content of those messages. If we look at XIUC 30130, please. And we see that this is an email dated the 15th of October. And we'll see at the bottom of the page, if that could just be highlighted, that the position taken by XIUC is that you had determined that there's no way it can disclose the content data, including the content of direct messages from AR to the inquiry via a Section 21 notice, without violating laws that are applicable to it. In order to provide the inquiry with content data responsive to its request lawfully, we respectfully ask that the inquiry applies for an order to obtain the content data pursuant to Section 4 of the Crime Overseas Production Orders Act 2019. If you can't help in relation to this, you must say so. But just 2 matters arising out of that. XIUC were already on notice that this inquiry couldn't issue either an MLAT or a crime overseas production order because these are not criminal proceedings. Do you know why it continued to insist on the provision of something which the inquiry had made clear it couldn't provide?
No, I'm sorry, I don't have the legal definition or thought process behind those decisions.
And we know that in contrast to the approach taken by X, Meta, dealing with AR's Instagram account, who may be thought to be in a similar position to X, did disclose the content data and didn't seem to think that the US legislation posed a difficulty to that, because upon request and a Section 21 notice, they did provide it. Are you aware of why X are taking a more restrictive understanding of what they're permitted to do than Meta?
Unfortunately, I don't understand the difference or why Meta would do that, and I'm not obligated to know their reasoning behind it. There's a lot of variables that come into play when making these assessments In some instances, data where it's stored and how it's stored comes into that. I don't know enough to be able to give you a clear answer on that. I'm sure our attorneys can give you that reasoning.
That's a legal issue. All right.
Yeah, it is a legal issue, yes.
You will remember how general the request for information was. We're also, obviously, for reasons that will be obvious from the questions that I've asked of you, keen to understand what date of birth was associated with AR's accounts. And what the inquiry was told in correspondence last night is that IUC does have the date of birth for one of the accounts, but doesn't for the others because, given the passage of time, the data has been destroyed. Now, it's not the first time the inquiry has come across data being destroyed after a period of time, and I don't have any questions about that. But in relation to the date of birth that X-Corp do have, ex-IUC was served with a Section 21 notice this morning asking for that information. Are you able to now tell us what the date of birth was that AR gave?
I was able to confirm that that was received and that the team is looking at that and will respond accordingly, but I don't have that at the moment, no.
I'm only going to ask this one further question. Why is it, having received a Section 21 notice signed by the chairman this morning, that you're not in a position to give that information now?
I don't even know what time it was received by whom and how long that assessment takes. So I can't speak to the length by which that response is going to be. It could be that it just wasn't received by somebody before we started this inquiry. I have no idea.
All right. You understand that the broad nature of the original request means that it would have fallen within the terms of the original request. Do you want to see it again?
Honestly, this is not an area that I really engage in. I apologize. I mean, the legal space is not my space.
All right. Would it be embarrassing to X for it to be publicly clear that he entered a false date of birth and that was the only requirement and that's why he was able to access sensitive material?
I don't think that it's a matter of embarrassment. Well, our policies are clear and the actions have been clear, and I've been very vocal throughout this entire testimony on how we approach things, and so I don't think their decision is based on embarrassment.
Thank you. Turning to AR's searching of the video on X, I want to deal with the sensitive issue of the events of the 29th of July. You'll appreciate the seriousness of the attack with which this inquiry is engaged.
Yes, of course.
3 very young girls stabbed to death, 8 more stabbed and injured, 15 girls inside, all psychologically traumatized, in most cases in the most profound way. 2 adults, in addition, stabbed, a further adult psychologically traumatized as she tried to shield one of the vulnerable young girls. That occurred around a month and a half after the Commissioner discontinued the litigation in Australia, yes?
Yes, I believe. If the timeline is there, yes.
We know now from the police investigation that AR searched X with the term Marmari Emmanuel stabbing at 11:04:09 on the morning of the attack, so MERP 300926. And when one of the investigating officers repeated that search on X in the course of the investigation, it navigated to media tabs in X that had posts still containing the actual video footage. And as I touched on earlier on in my questioning, that was done just 6 minutes before he left the house to get the taxi to carry out the attack. Does the proximity of AR's use of X as a child to seek to access that material, does the proximity in time of him using your platform to the attack concern you and the corporation?
I don't know that I can speak to the reasoning behind why he would look for a video like that. As I outlined before the break, I see the video in a very different way than somebody else does. And so for me to make an assumption that he was looking for that video to conduct a heinous attack, I mean, I'm not a criminologist or a psychologist, and neither is anybody at the company. So
no, but my question,
can't make that determination.
You'll forgive me, but you do need to seek to answer my question. My question was whether the proximity and timing of AR using your platform to seek to access this earlier terrorist attack concerns you and the corporation. Is that a matter of concern to the corporation?
I think it's a matter of review. I'm not sure we always look and review and work with law enforcement to better understand a situation. So yes, of course.
And if you say, yes, of course, we need to look to law enforcement, was anything then done reflecting on that?
I don't know. I don't know what type of engagement there was during that time.
Well, was there positive consideration to taking it down? Because
there was, I don't know what the discussion was with respect to taking it down. We went through the assessment of how we looked at the video and the determination that was made to keep it up. So my assumption is that there was some discussion about that. And in the context that I laid out earlier, the determination was to keep it up for the reasons that we've discussed.
Your evidence, if you would forgive me for saying so, has been very clear as to the rationale for why in the Australian litigation, X Corp defended what it would have seen as its right to keep the material up. But again, to the outside observer might think that for you as an organisation, this was the nightmare scenario. You fought to keep this material online. You've gone through a court process to establish that right. And then within a very short space of time, a brutal attacker has watched the footage or sought to access the footage through your platform just minutes before launching a murderous attack. Can you really not tell us, as the corporate witness for X, what that led to in terms of reflection and thinking about whether something needed to be done in terms of taking the material down?
You're assuming that when every heinous crime is committed, that anybody who has looked at something on our platform, that was some level of trigger that we have to assess and then decide to take down content. In order to do that with 500, 600 million posts and thousands and millions of videos and people's behavior, we would essentially be censoring information every single day. And as I started in the discussion, that is not something that we're willing to do. That is not what we stand for. It was hardly likely to dissuade him from carrying out a murderous attack, was it? I don't know what he was thinking when he did that, nor am I in a place to want to know that. And so I can't make the assumption that that video was a trigger.
The view of the British government, HOM 4092, the chair has seen this, HOM 4092. The chair has seen this letter, and I'm hoping that you're familiar with every line of this letter. Yes?
I've read the letter, but I mean, I haven't memorized it, but yes, I've read the letter.
No, I'm not, don't worry, I'm not going to test you on the content, but I don't think I need to read it all out. But the effect of this is to put social media companies on notice of the profoundly worrying fact that AR, the Southport killer, had access to violent online content in the years and indeed the days before the horrific murder, as we see in the first paragraph. And then without reading it all out, two aspects were particularly flagged. One I don't need to ask you about, which was the availability of an academic article containing the entirety of very damaging material from the Al-Qaeda training manual. but the second was the Bishop Emmanuel stabbing. And you see at the bottom, the ease of access to such dangerous illegal content is unacceptable. If we go over the page, there's an encouragement for the social media companies to take action in relation to this, and indicating that at that time the video had been removed in Australia following the issuance of Class 1 removal notice. We know that that changed. However, it's still available to view in the UK. We're therefore, the government's words, urgently asking you to ensure that this is removed from your platforms, to ensure that it is not used to inspire other attacks. Are you suggesting that the two Secretaries of State were making assumptions when they asked X to take this material down to ensure that it wasn't used to inspire other attacks?
Well, we don't have any proof that says it, and within the law if this was illegal in the UK, then we would have received an order from the government asking us to take it down, and we would have reviewed that.
But you were being asked as an exercise, I think, here of discretion, of policy, what might be thought of as decency to take the material down, not as a matter of law. So no doubt that's why the Secretaries of State were phrasing it in terms of an urgent asking to ensure that it is removed, to ensure that it is not used to inspire other attacks, yes?
Sure, yes, that was the intent of the letter.
And looking at responses to that, I'm not going to bring it up, but it's fair that I should note that Google indicated that as a search engine it was in a slightly different position, but it talked about how it had measures to reduce the visibility on search results of imagery that may correlate with violent extremism. But in terms of online platforms, TikTok, HOM 30193, started their letter to the Secretaries of State in the first paragraph by saying, like everyone, we were shocked and appalled by the attacks that unfolded on the 29th of July, and indicated that their thoughts remain with the families of Alice, Bibi and Elsie, as well as with the other victims. At the middle of the page, they said it had a zero tolerance policy for violent extremism or terrorist content. If we go to page 2, they indicated in their second paragraph that TikTok had prevented and removed thousands of attempted uploads of the attack. So for our purposes, the important thing there is that TikTok had agreed and were positively taking action to prevent uploads of this attack. Do you see that there?
I see it, yep.
And then if we go to Meta at HOM, just before we leave, could we just go to page 3 of the TikTok response? And you see that the person that TikTok thought should respond to that was their Director of Public Policy and Government Relations, TikTok UK and Ireland, all right?
I see that.
We look at the Meta response, HOM 30194. Meta's response, it's dated the 4th of February. They too started by indicating how shocked they were by the horrific attack. And indeed, they'd set up and established an internal working group to deal with the implications for their platform of material that was rising, no doubt not just the attack, but the riots that followed. At the bottom of the page, the first bullet point, they said, we do not allow organisations or individuals that proclaim a violent mission or are engaging in violence to have a presence on Facebook and Instagram. If we go over the page, they say that they immediately scaled reviewers to remove footage and prevent uploading of this attack. So they too, like TikTok, had decided that it had to be removed, and they were proactively doing it. And if we look at how they were communicating with the UK government, we'll see at the bottom of that page that they signed that off from their Director of Public Policy as well. When we contrast that with X's response at HOM 30196, and I think by this time you were in post, yes?
What was the date on that? I'm sorry?
It's the 11th of February 25.
Yes.
Yeah. Did you write this?
Did I write that?
Yeah.
I signed it. I didn't write it, but I signed. I think I was the one that, was I the one that signed it? I don't even know. I've signed a few of these documents that have been submitted, but I'm not sure that I was the one that signed that one.
If we just go to page 4, it wasn't signed by anybody.
Okay. So no, I did not. I did not personally write that.
No. So page 1, and I don't want to spend too long on this, but it does stand in contrast to other social media platforms that the letter starts with an appreciation of the engagement on the important matter. I'm not going to go through the totality of the letter to prove a negative, but nothing was said about the victims or the horrifying nature of the attack or sorrow in relation to it. Was there a reason for that?
I'm sorry, I don't know.
And then on page 3, again, I'm not going to go through it all, but we see in the middle of the page that you relied upon the Australian government's litigation. We uphold it's in the public interest to view this footage should they wish to do so. Additionally, the Bishop himself has expressed that the public should be allowed to see the footage. Yes?
Correct.
And so, would you agree that the position that the Australian court had already averted to, whereby my words, not the judge's words, but that X was something of an outlier, has now become more firmly entrenched? Because in response to the Secretaries of State's letters, the other major social media platforms have agreed to take positive action, and it's been removed. And X have doubled down.
I don't think that that's an accurate perception or representation. We haven't doubled down. We've been consistent in our free speech mission. We've been consistent in our messaging. And yes, I mean, if you want to call it an outlier, we are an outlier in many ways. One, we don't have the level of children and engagement that the other platforms do.
You had AR as a child.
Again, we don't have the magnificent amount of children. It is an adult site meant for a global dialogue for adults to understand what is happening through the world. And we are an anti-censorship company. And so any attempts to censor information that is out there is going to be looked at through that lens. Is it legally something that a government can do because under their laws they can do that, and we will comply in those situations? But beyond that, that is the lens by which we see the world. And so you're right, we are an outlier from those platforms, and we're proud to be an outlier, and we're proud to be the defenders of free speech globally.
You did have AR as a child, using your platform to seek to access this attack, yes? And it might be thought it's not an excuse of that you only have 198,000 children, and that's a small percentage. This attacker used your platform to seek to access this material. Surely that was something that was quite sobering for any responsible organization.
I mean, of course we're going to assess that.
Was there any level of soul searching by X Corp about this? Look, this was close to the line previously. We defended it in the Australian litigation, but having some sensitivity to what's happened here, we should have the moral courage to reverse our position. Was there any thinking along those lines?
Look, I can't say what discussions happened during that time or what soul searching occurred.
I'm sorry, forgive me, but you were in post by now in response to the letters, and I'm looking at that stage.
What I was saying is I wasn't part of the discussion of what the decisions were made. What I will say that What our guide is, that taking the God-given right of freedom of speech, freedom of religion, and freedom of expression from the masses because of the very few that have committed horrendous crimes is not something that we take very lightly. That is a very serious and something that our company stands behind and our people stand behind and our platform stands behind very seriously. So if I were part of that discussion, which I wasn't, that's what I would remind people, is that we have a mission and we believe that information is power and that censorship does not have a place, especially in situations by which we have assessed legally, we have discussed with governments, we have challenged legally, and we have very clearly are abiding by the law and are in compliance.
None of my questions have suggested for a moment that this was a matter of legal duty to take it down, but I'm interested in social responsibility, discretion, and reflection on events. Did you not think to inform yourself before you came to give evidence of what exact discussions had gone on that led to the unnamed response to the letter from the British government that was sent by X? Did you not think to say, before I go to give evidence of this inquiry, I better understand exactly what reflections we had, who was taking those decisions? That's important information.
Well, I mean, I think we went through what the context was earlier for the reason for leaving the video up and what decision was made in that context. But I think what we have to understand here is every government, every culture, every being, every belief system in the world is going to have a different context and a different view and a different opinion on what should be allowed and not allowed. And if X is going to respond to every single one of those, that is essentially censorship. And that is not something that we're willing to do.
Can you understand the sense of anger and dismay that is no doubt felt by the victims and the families of the children who died, knowing that AR used X to search this material just 6 minutes before he set off to launch the attack, and that X continues to refuse to take it down? Can you understand those feelings of anger and dismay
Of course.
on the part of the victims?
Absolutely.
And when we go back to ILT 4078, it must be right that an X-Corp's approach to these difficult matters, the importance of free speech is more important than the victims and their feelings of this atrocious attack.
The importance of free speech is literally the stronghold of all of our governments, all of democracy, and everything that we should stand for as a people. And I will go back to giving you my personal, since you're going to put up my personal page as a reflection of X Corp. My personal position on this is that I come from an oppressed country that limited my family's free speech, that limited my family's freedom of religion, that limited my family's capability, and in fact were persecuted over it. And so when we seek refuge to countries like the great countries like the United Kingdom, like Australia, like Canada, like the United States, for a reason. And it is because we are able to have those liberties, to have those freedoms, to have that capability. If you're asking me right now that I should start to limit in any way those free rights of people because I am emotionally responding to a horrific attack, then we would be limiting the rights of people every single day. Because every single day, bad things happen. Every single day, attacks happen. Every single day, there are horrific attacks in this world. And if our reaction to that is that we're going to be limiting the individual's rights in order to somehow provide some level of false safety. If you're going to put up my page personally as a reflection of that, I'm going to tell you that personally, I don't agree with that. And that essentially is not what our country stands for.
Ms. Konishi, those are my questions. I turn to my left to see if there are any others from the call participants.
Yes, Mr. Chairman.
You know what I mean by a VPN?
I do, yes, sir. I can't see you, so I'm assuming it's a gentleman standing there?
Can you see me now?
No.
Do you want to come here to ask a question?
I'm so sorry. Just bear
No, that's
with me.
okay. I just don't want
Ms.
to assume that.
Konishi, the gentleman who is asking you questions is Mr. Chapman. He asked questions on behalf of the bereaved families.
Okay, thank you.
Is that better?
Hello.
Yep, got it.
I can see you now, yes.
So you said you knew what a VPN is,
I am aware of a VPN, yes.
and they are commonly available and used. Is that
I believe
right?
so, yes.
And easy to use.
I mean, I don't use one, so I'm not 100% sure, but I would say it's likely easy to use.
Including by children.
I don't know how many children actually are on VPN, sir, I'm sorry.
Okay, well, we know in this case that the perpetrator did use a VPN.
Okay.
Can I take it that X regards VPN as an important bastion of fundamental freedom of access to online information?
I mean, I think that we believe in freedom of online information. I don't know whether a VPN or the use of a VPN, I've not had that discussion specifically, but yes, access to information is very critical for us.
Well, we heard from Mrs. Connolly, the regulatory witness, that she accepted that there were legitimate uses for VPNs. Would you agree
Correct.
with that?
Yes, I believe so.
And it'd be part of your free speech mission, would it not, to enable the use of VPNs to access X's services?
I believe so. That would be an accurate statement.
And I'd be right in saying that X has no intention of restricting access to its services through VPNs?
No, it's never been discussed, so at least not with me, so I would say that's an accurate statement.
And a VPN, as you know, allows the user to disguise their location and their identity.
It does.
Would you suggest then it's somewhat academic to talk of restricting access to harmful content to children when those restrictions can be readily evaded by the use of a VPN?
I'm not sure I follow. Can you explain to me what you mean by that? I want to understand for sure.
Well, if a VPN enables a child to disguise its location and identity, that is a way of evading any restrictions that you as an organisation might hope to put on access to your material.
I would, yeah. I mean, if the VPN is, if you're asking if it's a way around all of the restrictions that we put in place, I don't know the technical capabilities of a VPN. I would assume that that's the case, but I don't know if that's actually how it works. To be completely honest.
So you assume that indeed a VPN can evade those restrictions? Yes.
My assumption is today, whether future technologies don't allow for that, I'm not sure. It could be that we create a technology that doesn't allow for that.
That's an important thing, isn't it, in this discussion about restricting access VPNs?
It's important as in...
Well, if it's academic, if you can just get around the restrictions, it's somewhat academic to talk about a lot of detail about how we restrict that access.
Yeah, I mean, look, I can't determine, or I'm not here to state whether VPN has played a role or is playing a role in, going around regulations or going around restrictions. I don't know to what level people use VPN or to what level children use VPN, so I don't know if that's a normal, mass used way. I can't speak to that as a matter of practicality.
You didn't mention anything.
I'm not sure how profitable this is going to be.
Very well. I'll move on to the next topic. Tagging of information on X. Do you know what I mean by tagging?
I don't. As in
Hashtags.
trending or hashtags? Okay.
Do you know what I mean by that?
Yes.
So that's where I think a user will tag their content to identify the subject matter of that post.
Okay.
Is that right?
It is widely used across social media as a hashtag in order to create a trend. Yes.
And are you aware of the practice of false tagging?
No, I'm not.
You're not aware that some users mischievously tag their content in a false way so that it gets revealed in search results?
Oh, yes. Okay. Yes. Okay.
You're aware of
Yep.
that?
Yes.
And is that not a way that people who are targeting children could flag their information so that it appears in totally innocent search results that children might make?
Well, our position on hashtags or tagging has been very clear for a period of time that we actually disincentivize the use of tags. We don't. It's something that we have been pushing away from for some time now through major upgrades to how we communicate on the platform, and have actually told our users through numbers of different communications that hashtagging on our platform is not. It doesn't really work well and is unnecessary.
Algorithms. Does X deploy algorithms to flag content that they think the user might be interested in?
The algorithm is catered to the user's interest.
So would I be right in saying that those interests can be reinforced, if you like, so that the user gets to see more of what they've searched for?
Not necessarily. It's not that easily defined, as in if you continue to want to look at something, you're always going to be able to see it. There is friction built into the system such that if something is, as an example, restricted from reach because it is against a policy, it wouldn't matter even if an individual wanted to see it. It wouldn't show up in the algorithm. So it just depends, but it's not just an open capability to continue to see things. There is friction built into the system for violative content, for restricted content. The algorithm does not give it to you. You would have to specifically search for it. Go to the person's page or whatever it may be if it's still online. So while it's generally true that the algorithm does cater to your personal likings, there is friction built in for things that are against policy.
Do you know whether there has been any research by Exxon to whether interest in violence would result in the user being served up with more violence?
I don't know if I don't know that answer. I'm sorry.
You were asked by Counsel to the Inquiry about the link between offline and online harms. Do you recall?
I might. I mean, you maybe give me a little bit more. It's been 3 hours,
The
so
association,
sorry.
the association between real-life violence
Yes.
and online violence. You were asked about that. Has X done any research about the potential link between offline and online violence?
I don't know of any research that we've done.
You don't know?
I can't answer that. I don't know. I'm sorry. No.
If there has, would you be willing to share it with the inquiry?
I think if you put in a request and we put it through the process, if there has been any research, we will assess that request.
But even if that research showed that there was a link, would I be right in understanding your evidence that it's a price worth paying?
I don't know. I don't know what the research says, and we haven't had that assessment. So I can't make an assumption of how the company is going to feel or what their response is going to be based on that research.
Thank you.
Wait, I mean, I don't know what that answer could be.
Thank you.
Yes.
Thank you, sir. Good afternoon, Ms. Canoniscio. I ask
Hello.
questions on behalf of the families of the other child victims. Just a couple of questions about age verification, please. You were asked about the age verification process before the Online Safety Act came into force. and that involved the submission of a date of birth by the user. You were then asked about steps that X is taking now to verify the age of its users on the platform today, including live selfies and the submission of government IDs. That's right, isn't it?
Yes.
Is it fair to assume there may be some children on X who registered an account before the Online Safety Act came into force, who've provided a false date of birth, and who would appear in X's data as an adult?
Yes, I mean, yes, it's based on the date of birth that's provided. So going on the data, that's what it would show.
What steps is X taking proactively to identify users that fall into that category?
Well, now that we're working with the installation of the age verification system, as we're rolling it out, there are proactive steps as were outlined to go back and look at those accounts, reassess where they are, and then in those situations where there are questions, there will be identification required as per law.
And that applies not only to new users creating an account today, it would also
Correct.
apply retrospectively.
Correct.
Thank you very much. Thank you, sir.
Thank you very much, Mr. Ridley. I'm afraid you can't see me, Ms. Cananishu, but I'm the chair.
I can see you, yes.
Oh, you can?
Yes.
I'm very grateful for you taking out time from your from a schedule that I know at the moment is very busy for you. That now completes your evidence, and we will therefore terminate the link. But thank you for your assistance.
Thank you all.
So thank you. We now have an enforced break because we need to make some technical arrangements. So that may take some time. Could I ask for 20 minutes? But I have to say that it may take as long as 30, but we'll do it as quickly as we can.
Certainly.
Thank
well, 5 past, but let me know.
Thank you.